everyone had received amnesty and these issues had become moot. So I don't think the history tells us.
Sort of look at Justice Thomas's question sort of from the 30,000-foot level. I mean, the whole point of the 14th Amendment was to restrict state power, right? States shall not abridge privileges of immunity. They won't deprive people of property without due process. They won't deny equal protection. And on the other hand, it augmented federal power under Section 5. Congress has the power to enforce it. So wouldn't that be the last place that you'd look for authorization for the states, including Confederate states, to enforce, implicitly authorized, to enforce the presidential election process? That seems to be a position that is at war with the whole thrust of the 14th Amendment and very ahistorical.
No, Your Honor. First, we would locate the state's authority to run presidential elections not in the 14th Amendment, but in Article 2. And that power is nearly plenary to determine.
Yeah, but you're relying on – you have no reliance on Section 3. Is that what you're saying?
No, Your Honor. Certainly we have reliance on Section 3 insofar as Article 2 gives states this broad power to determine how their electors are selected, and that broad power implies the narrower power to enforce federal constitutional qualifications.
Well, but the
like
narrower power you're looking for is the power of disqualification, right? That is a very specific power in the 14th Amendment. And you're saying that was implicitly extended to the states under a clause that doesn't address that at all.
We would say that nothing in the 14th Amendment takes away from the states their broad and nearly plenary power to determine the manner of selecting their electors in the manner that they see fit. As this Court said in Chiafalo, that power is nearly plenary unless something in the Constitution tells states they can't do it. And the structure of the 14th Amendment certainly was intended to expand federal power and certainly to restrict state power in some ways. But states are bound to enforce and apply, for example, Section 1 of the 14th Amendment. And so it's hard to see why states wouldn't be similarly bound or at least authorized.
That's not greater includes the lesser argument. The states have the power, the legislature has the power to choose electors, granted. But just because there's one authorized means in the Constitution to a particular end does not mean that there's any means to that end. And so I think you're taking that electors argument and bringing it into Section 3, where, as the Chief Justice says, there's just no and Justice Thomas, there's no historical evidence to support the theory of Section 3 nor the overall to explain the overall structure of the 14th Amendment.
We certainly have a long history in this country of states using their power to determine the manner of selecting presidential electors to enforce other qualifications in the Constitution. I don't take it there's a great debate about whether or not states are allowed to exclude underage or foreign-born candidates, or if President Bush or Obama wanted to run for a third term, that they could be excluded under that broad Article 2 power. I don't see why Section 3 should be treated any differently. Section 3 speaks in the same
Well, when you look at
terms.
Section 3, the term insurrection jumps out. And the questions are, what does that mean? How do you define it? Who decides? Who decides whether someone engaged in it? What processes, as Justice Barrett alluded to, what processes are appropriate for figuring out whether someone did engage in that? And that's all what Chief Justice Chase focused on a year after the 14th Amendment to say, these are difficult questions, and you look right at Section 5 of the 14th Amendment, as the Chief Justice said, and that tells you Congress has the primary role here. I think what's different is the processes, the definition, who decides questions really jump out at you when you look at Section 3. Your response to that?
Well, certainly, Justice Kavanaugh, there has to be some process for determining those questions. And then the question becomes, does anything in the 14th Amendment say that only Congress can create that process? And Section 5 very clearly is not an exclusive provision. It says Congress shall have power.
But maybe put most boldly, I think that the question that you have to confront is why a single state should decide who gets to be president of the United States. In other words, this question of whether a former president is disqualified for insurrection to be president again is, just say it. It sounds awfully national to me. So whatever means there are to enforce it would suggest that they have to be federal national means? Why does, if you weren't from Colorado and you were from Wisconsin or you were from Michigan, and it really, what the Michigan Secretary of State did is going to make the difference between, whether candidate A is elected or candidate B is elected. I mean, that seems quite extraordinary, doesn't it?
No, Your Honor, because ultimately it's this court that's going to decide that question of federal constitutional eligibility and settle the issue for the nation. And certainly it's not unusual that questions of national importance come up.
Well, I suppose this court would be saying something along the lines of that a state has the power to do it. But I guess I was asking you to go a little bit further and saying why should that be the right rule? Why should a single state have the ability to make this determination not only for their own citizens but for the rest of the nation?
Because Article 2 gives them the power to appoint their own electors as they see fit. But if they're going to use a federal constitutional qualification as a ballot access determinant, then it's creating a federal constitutional question that then this court decides, and other courts, other states, if this court affirms the decision below, determining that President Trump is ineligible to be president, other states would still have to determine what effect that would have on their own state's law and state procedure.
Well, I mean, if we affirmed and we said he was ineligible to be president, yes, maybe some states would say, well, we're going to keep him on the ballot anyway. But, I mean, really, it's going to have, as Justice Kagan said, the effect of Colorado deciding. And it's true. I just want to push back a little bit on, well, it's a national thing because this court will decide it. You say that we have to review Colorado's factual record with clear error as the standard of review. So we would be stuck. The first mover state here, Colorado, we're stuck with that record. And, I don't want to get into whether the record, maybe the record is great, but what if the record wasn't? I mean, what if it wasn't a fulsome record? What if, the hearsay rules are, one-offs? Or what if this is just made by the Secretary of State without much process at all? How do we review those factual findings? Why should clear error review apply? And doesn't that just kind of buckle back into this point that Justice Kagan was making, that we made with Mr. Mitchell, too, that it just doesn't seem like a state call?
3 points, Your Honor. The first is that ordinarily, of course, this court reviews factual findings for clear error, but President Trump made the point in his reply brief that sometimes on constitutional questions that require a uniform resolution, this court can do something more like a Bose Corp-style independent review of the factual record. And we would have no objection to that, given that the record here, really the facts that are disputed here are incredibly narrow. The essence of our case is President Trump's own statements that he made in public view for all to see.
But then that's saying that in this context, which is very high stakes, if we review the facts essentially de novo, you want us all to just watch the video of the ellipse and then make a decision without any deference to or guidance from lower court fact-finding? That's unusual.
Well, ultimately, President Trump himself urges this court to decide the merits of his eligibility on the factual record here at page 2 of his brief. He's never at any point in this proceeding suggested there was something else that needed to be in the factual record, any other witnesses that he wanted to call to present his case. And again, the essence of our case is his own statements, and in particular, his own videotaped statements on the ellipse.
Mr. Murray, just to circle back to – I'm sorry to interrupt, but I wanted to – before we left it, I wanted to circle back to where Justice Kagan was. Do you agree that the state's powers here over its ballot for a federal officer election have to come from some constitutional authority?
Members of this court have disagreed about that.
I'm asking you.
The majority of this court has said that those powers come from Article 2, but we think that the result is the same whether the court locates it in Article 2 or in a reserved power under the 10th Amendment.
But you accept that this court has held. You're not contesting this or asking us to revisit that decision in Thornton or term limits or whatever you want to call it, that it has to come from some federal constitutional authority.
No, we are not, Your Honor.
Okay. And here we're not talking about the qualifications clause, right? Nobody's talking about whether he's 35 years old or natural born, whatever, right? Not at issue, okay? We're talking about something under the 14th Amendment and Section 3. So that's where you have to find your authority, right?
We find our authority in Article 2, in states' plenary power to run their elections.
Federal election, but this is for a federal office. It has to come from the Constitution, and you're seeking to enforce Section 3.
We're suggesting that in their broad power to determine them, to select presidential electors in any manner they see fit, they can take account of Section 3 and apply Section 3.
Could they do it without Section 3? Could they disqualify somebody for, on whatever basis they wanted outside of the qualifications clause?
That would run into term limits, I think.
Yeah, I would think so, right? So it has to come back to Section 3. And if that's true, how does that work, given that Section 3 speaks about holding office, not who may run for office? It was a point Mr. Mitchell was making earlier, and I just wanted to give you a chance to respond to it, because it seems to me that you're asking to enforce in an election context a provision of the Constitution that speaks to holding office. So it's different than the qualifications clause, which is all about who can run and then serve. Yeah.
I don't know that it is different.
Okay.
Other qualifications for office similarly talk about eligibility for the office. There's nothing unconstitutional about a 30-year-old trying to get on the ballot.
Except for this disability can be removed, right, under Section 3. That's what's different about it. So thoughts on that?
Well, the fact that there's an extraordinary provision for removing the disability does not negate the fact that the disability exists today, and it's existed since January 6, 2021, when President Trump engaged in insurrection against the Constitution.
So were his actions after that date, before he left office, ultra vires? Is that where your theory leads?
Well, that would raise the separate question of whether one can collaterally attack the actions of a de facto officer. And that may be the one place in Griffin's case at the very end where we would agree, which is when Justice Chase said, I've talked to my Supreme Court colleagues and we unanimously agree that you can't collaterally attack all official actions of an officer who's in fact holding the position under Section.
But just circle back to where we started, right? That this is Section 3, your authority has to come from there, and it's about holding office, and it's a particular kind of disability that can be removed by Congress, and it's the only one like that, right? They can't remove age or citizenship. How should that inform our thoughts about a state's efforts to regulate the ballot for a federal office?
The colloquy that my friend had with Justice Alito earlier, I think, is illustrative here. The fact that Congress has an extraordinary removal power does not negate that the disability exists today and exists indefinitely into the future, much like the fact that that the president can pardon somebody for a criminal conviction doesn't make that conviction somehow contingent. And I would note that if President Trump were appointed to an office today, if he were appointed as a state judge, he could not hold that office, which shows that the disability exists now. And the fact that Congress has a power to remove the disability doesn't negate the present qualification, nor does it implicitly bestow on President Trump a constitutional right to run for offices that he cannot hold in violation of state law and state procedure under Article 2.
In fact, there was a congressional action to permit Confederate officers or people who supported the Confederacy to hold office before the 14th Amendment, correct? So there must have been a thought that there was a pre-existing disqualification.
That's absolutely right. There were a flood of amnesty requests even before Section 3 went into effect because everybody understood at the time that those people would be disqualified the moment that Section 3 was enacted forever unless they received amnesty.
Counsel, what do you do with what would seem to me to be plain consequences of your position? If Colorado's position is upheld, surely there will be disqualification proceedings on the other side, and some of those will succeed. Some of them will have different standards of proof. Some of them will have different rules about evidence. Maybe the Senate report won't be accepted in others because it's hearsay. Maybe it's beyond a reasonable doubt, whatever. In very quick order, I would expect, although my predictions have never been correct, I would expect that a goodly number of states will say, whoever the Democratic candidate is, you're off the ballot, and others, for the Republican candidate, you're off the ballot, and it'll come down to just a handful of states that are going to decide the presidential election. That's a pretty daunting consequence.
Well, certainly, Your Honor, the fact that there are potential frivolous applications of a constitutional provision isn't a reason.
Well, no, hold on. I mean, you might think they're frivolous, but probably the people who are bringing them may not think they're frivolous. Insurrection is a broad term, and if there's some debate about it, I suppose that will go into the decision, and then eventually we would be deciding whether there was an insurrection when one president did something as opposed to when somebody else did something else. And what do? Do we wait until near the time of counting the ballots and sort of go through which states are valid and which states aren't?
There's a reason Section 3 has been dormant for 150 years, and it's because we haven't seen anything like January 6th since Reconstruction. Insurrection against the Constitution is something extraordinary.
It seems to me you're avoiding the question, which is other states may have different views about what constitutes insurrection. And now you're saying, well, it's all right because somebody, presumably us, are going to decide, well, they said they thought that was an insurrection, but they were wrong. And maybe they thought it was right. And we'd have to develop rules for what constitutes an insurrection.
Yes, Your Honor. Just like this Court interprets other constitutional provisions, this Court can make clear that an insurrection against the Constitution is something extraordinary. And in particular, it really requires a concerted group effort to resist through violence, not some ordinary application of state or federal law, but the functions mandated by the Constitution.
On your point
itself.
that it's been dormant for 155 years, I think the other side would say the reason for that is Chief Justice Chase's opinion in 1869 in Griffin's case to start, which says that Congress has the authority here, not the states. That's followed up by the Enforcement Act of 1870, in which Congress acts upon that understanding, which is followed, and there's no history contrary in that period, as Justice Thomas pointed out. There's no history contrary in all the years leading up to this of states exercising such authority. I think the reason it's been dormant is because there's been a settled understanding that Chief Justice Chase, even if not right in every detail, was essentially right, and the branches of the government have acted under that settled understanding for 155 years. And Congress can change that. And Congress does have Section 2383, of course, the Insurrection Act criminal statute. But Congress could change it, but they have not in the 155 years in relevant respects for what you want here today, at least.
No, Justice Kavanaugh. The reason why it's been dormant is because by 1876, essentially all former Confederates had received amnesty. And we haven't seen anything like an insurrection since then. I'd like to address your point.
Well,
Can I go to that point?
After the
Justice Alito?
I don't know how much we can infer from the fact that we haven't seen anything like this before and therefore conclude that we're not going to see something in the future. From the time of the impeachment of President Johnson until the impeachment of President Clinton, more than 100 years later, there were no impeachments of presidents. And in fairly short order over the last couple of decades, we've had 3. So I don't know how much you can infer from that.
Certainly, but if this Court affirms, this Court can write an opinion that emphasizes how extraordinary insurrection against the Constitution is and how rare that is, because it requires an assault not just on the application of law, but on constitutionally mandated functions themselves, like we saw on January 6th, a coordinated attempt to disrupt a function mandated by the 12th Amendment and essential to constitutional transfer.
Well, let me ask you a question
power.
about whether the power that you've described as plenary really is plenary. Suppose that the outcome of an election for president comes down to the vote of a single state, how the electors of the vote of a single state are going to vote. And suppose that candidate A gets a majority of the votes in that state, but the legislature really doesn't like candidate A, thinks candidate A is an insurrectionist, so the legislature then passes a law ordering its electors to vote for the other candidate. Do you think the state has that power?
I think there may be principles that come into play in terms of after the people have voted that that the state can't change the rules midstream. I'm not sure because I'm not aware of this Court addressing it. And certainly as
let's change it so that it's not after the election. It's 3 days before the election based on the fact that the polls in that state look bad. Can they do it?
I think they probably could under this Court's decision in Chofalo, where this Court emphasized that for much of American history, state legislatures picked their own electors and assigned their own electors themselves. But, of course, that would be much more extraordinary than what we have here, which is simple application of normal state ballot access principles to say that we're only going to put on the ballot an individual who is qualified to assume the office.
Could I ask you again the question that Justice Gorsuch asked, and to which you responded by citing the de facto officer doctrine? But suppose we look at that going forward rather than judging the validity of an act committed between the time when a president allegedly engages in an insurrection and the time when the president leaves office. During that interim period, would it be lawful for military commanders and other officers to disobey orders of the president in question?